30% to EMEs and QSEs, which are at least 51% Black owned. This can also be said to be in consideration of Section 217 2 and 2171 of the Constitution. Now, it's these sections that I've just spoken of, which then were taken to court by Agribusiness and NCP. And I think in order for us to understand or at least to give context to the constitutional court challenge, it is necessary to then profile who Agribusiness is. Okay, Agribusiness as an organization, they challenge the regulations in court. In their website, they describe themselves as a business community that reforms failing business environments where it can and rebuilds them. Now, by necessary implication, business environments include public procurement, which then, as reviewing Agribusiness as an organization, they then believe that public procurement is an environment that is failing and that needs to be reformed. They then go on to state that when referring to the judgment, they say, and I quote, "We wish to emphasize that far more needs to be done to end the policy of BEE." They further state that they will expand its litigation initiatives regarding BEE in the months and years ahead in the interest of a flourishing economy and society. So then this gives us a picture that their main challenge is dismantling BEE. And they've previously stated such. The CEO, Pete Leroux, has previously advised that they've so far collected something in the region of 5.5 million rand dedicated towards the fight of dismantling BEE through the courts. The CEO has also quoted as stating in interviews that their overall fight is to challenge the transformation agenda because, according to them, it's destructive to the economy. I'm now going to hand over to my colleague, Mr. Tabani Mhlongo, who's then going to provide us with a synopsis of the judgments throughout the three courts.
Thank you, Lucky. And just a brief hello to everyone who's on the call. And so for the purposes of bandwidth, I just wanted everyone to just see who's presenting and just know that it's not a bot. But for bandwidth, I'll just switch off my camera from here on. Basically, in a snapshot of the judgments that brought us here, at first, Agribusiness launched an application in the High Court and sought an order reviewing and setting aside the 2017 procurement regulations. They brought this application in terms of PAJA. For those who don't know what PAJA is the Promotion of Administrative Justice Act. And they brought this application on the basis that the minister had acted beyond his scope of powers in enacting the regulations, and that the regulations therefore were invalid. So that's just a summary of the application brought without getting into too much detail into the arguments placed in support. Then the High Court then held that in comment that the 2011 regulations, which were the precursors to the 2017 regulations, also contain a pre-qualification criteria relating to the functionality, which were never challenged, but this was by way of comment, of course. And then the High Court also just highlighted by way of comment that the section of Section 217 on the Constitution, which my colleague has elaborated on, requires that public procurement by the state should be fair and objective, and then it permits organs of states to use public procurement process to achieve economic transformation. and take place in the context of regulatory framework which sets parameters within which the transformation policies of organs of state may be achieved. So with that background, the court then held that Business had placed undue emphasis on the points system set out in Section 21B of the Procurement Act, which some refer to it as the Framework Act. We'll use that term interchangeably. And 21B relates to the 90-10 and 80-20 rules. And for those who are unfamiliar, it provides that contracts that are designed, designated as high value, contracts with a value of about 50 million are to be evaluated out of a 100-point system, which 90 points allocated based on price and 10 points allocated based on the goals contemplated in that section. And then the 80-20 rule is, of course, the same principles, but instead of 90, it would be 80, and the threshold of valuation would be 30,000 to 50 million. So, and then the court then said that by placing undue emphasis on these sections, it ignored the Business ignored two very important features of the Procurement Act, namely that the pre-qualification criteria are acceptable because the Procurement Act envisages that before tenders are evaluated, they must first qualify by meeting the requirements of an acceptable tender, which is a term that is defined in Section 1 of the Act. And secondly, that the Procurement Act grants organs of state the ability to award a tender to a tenderer who does not score the highest points, provided that they satisfy other objective criteria. The court then further interpreted the inquiry in terms of the Procurement Act to take place in 3 stages. It said, firstly, it must be determined whether a tender meets the requirements of acceptable tender. And then secondly, go through the inquiry of the 90-10 and 80-20 point system. And then finally, it must then determine whether objective criteria exist that justify the award of the tender to a lower scoring tenderer. Based on these rationale, the High Court therefore concluded that Business gripe was not so much to the concept of pre-qualification criteria, but rather with the fact that their members fell outside of the category of persons that the 2017 regulation seek to advance. And then the court then said, therefore, Business complaint could not be said to be against the concept of pre-qualification, but rather that they fell outside of these advancement groups. And the court then held that the minister was authorized to promulgate the regulations. It thus rejected the argument that the minister had acted beyond the scope of his powers. And in the result, the High Court then held that the procurement regulations were rational and lawful and dismissed this application with costs. Naturally, Business appealed to the Supreme Court of Appeal. And then this was after considering the Procurement Act and Section 217 of the Constitution. The Supreme Court held that the minister had failed to act within his powers under the Act. And in justifying this, the court held that in light of Section 2 of the Procurement Act, the correct approach to evaluate tenders is to first ascertain the highest points scorer, and thereafter, if there are objective criteria, then justify the award of the tenderer to the lowest score, and the organ of state may do so. And it's the Supreme Court of Appeal also held that preliminary disqualification was impermissible as it was not consonant with the approach envisaged in 2171 of the Constitution. Consequently, that court held that the minister promulgated the regulations but identify specifically which regulations, which were the impugned regulations, as my colleague has mentioned, which was Regulation 3, 4, and 9, held that those regulations were unlawful. And then those procurement regulations were declared invalid as they were inconsistent with the Procurement Act and the Constitution, and then made the declaration of invalidity suspended for a period of 12 months. So the minister then decided to appeal that SCA judgment. And then in argument, the minister argued that the proper reading of Section 217 of the Constitution requires a consideration of South Africa's segregated past, and then submitted that Section 5 of the Procurement Act confirms wide regulatory powers to the minister, and that to the minister in that they can enact regulations with a wide discretion, and that the Supreme Court had failed to appreciate this power. As the regulation scheme they felt was flexible and enables the minister to make any regulation that advanced the objects of the Procurement Act. The minister then contended that the SCA erred in that it measured the legality of the regulation solely against the requirements of 217 of the Constitution, and did not attempt to read Section 2 and 5 of the Procurement or Framework Act harmoniously and while considering 217 of 2172 and 2173 of the Constitution. And then he then argued further that in any event, the regulations were not intended to replace the scoring system under the Procurement Act, but are contemplated in terms of the Act and of the Act's definition of an acceptable tender, to which the preference point system may be then applied. Business then argued that the Procurement Act does not empower the minister to create pre-qualification criteria that disqualify tenderers without recourse to their preference point score in Section 2 of the Act. Therefore, the regulations are, by that logic, inconsistent with the Act. Business also contended that any regulations made must be congruent with the provisions of Section 217 of the Constitution. And amongst other things, which are stated in 217 of the Constitution, they must be competitive and cost effective. Further, Business argued that the correct approach is to consider the highest point scorer and then consider whether the tenderer can be awarded to a low point scorer. This is in terms of Section 2 of the Procurement Act. Business advanced that the pre-qualification criteria overly narrowed the selection pool and therefore does not enable the state to find the most capable and cost-effective tenderer. The promulgation of the regulations, besides being outside of the scope of the minister's powers, was a breach of the separation of powers of the minister, which they argue the minister stepped into the lawmaker's territory. So the judgments were split in two, and the first minority judgment being penned by Judge Mohlanhla. The court, these were the unanimous findings. The court granted leave to appeal to the applicant. And the minority judgment then diverged on these reasons and outlined them in the following. They stated that the minister did not act beyond the scope of his powers conferred on him by the Procurement Act when promulgating the regulations, as the minister had power to make regulations regarding any matter that may be necessary or expedient to achieve the objects of the Procurement Act. I might highlight that this is relying on Section 5 of the Procurement Act. And then the minority held that the regulations were aimed at achieving the purpose of the Procurement Act in Section 217 of the Constitution, and that the proper reading of the procurement regulations would demonstrate that an organ of state has the discretion to implement the pre-qualification criteria. Thus, the minority upheld the appeal. The second judgment, which being the majority, penned by Judge Modlanga, also granted leave to appeal, but diverged with the minority on the interpretation of Section 5, and specifically with the reading of the words necessary and expedient. The minority judgment interprets the word necessary and expedient to be the limiting factor to the power of the minister to make regulations, rather than the factor that allows the minister to make regulations. The majority judgment comes to this conclusion by reading these words and to determine by saying that an organ of state must determine its preferential procurement policies. And then, since this is by reading of Section 2.1 of the Procurement Act, and since each organ of state is empowered to determine its own preferential regulations, then the majority states that it cannot also lie with the minister to make that same make those same regulations on the same point. Ultimately, the majority judgment holds that it can neither be necessary nor expedient for the minister to make regulations to seek the achievement of the Procurement Act when that already can be achieved by way of reading Section 2.1 of the Procurement Act. In that result, the majority dismissed the application the application to intervene and for direct access was dismissed by some, forget this word, by some interested parties. And then the leave to appeal was granted, but however, the Constitutional Court dismissed that appeal with costs. And the notable issues will be then dealt with by my colleague, Lakim Keys. Thank you.
Thank you, Tabane, for your presentation. Now, the pertinent issues, as indicated by the procession of the matter from the High Court SCA to the Constitutional Court, can be split into two. Number one is the constitutional muster of veracity of the impugned sections of the regulations. So whether or not it's constitutional and it's in accordance with 217 for there to be pre-qualification criteria. That's on the one end. Second end is whether or not the minister had or authority to enact the regulations in the first place. Now, in respect of the first issue that I've just identified, the High Court was of the view that those impugned sections align with Section 217 of the Constitution, more specifically 2172 and 2171. However, this was rejected by the SCA. However, the SCA's judgment, according to us, in that respect, is questionable. Now, the court has been criticized for this, in that academic opinion is that the court could have taken this opportunity to deal decisively whether or not the impugned sections of the 27 regulations do accord with the Constitution. However, they in paragraph 116 of the majority judgment, they dealt with the issue scantily, in that the Court says, happily, both the first judgment and this judgment, and indeed the minister, understand the imputed regulations to do what is envisaged in Section 217 of the Constitution. Now, the reason why, and which we agree, why academic opinion on this point that it's not sufficient, is that it's not quite definitive whether or not the court is saying the SCA's interpretation of the impugned regulations is incorrect, and that they therefore agree with the High Court's interpretation, or they're disagreeing with both High Court and ACA, and they are then advancing that this is how this issue must be viewed. However, on the face of it, we believe that it can be argued that in terms of this paragraph, the Court concedes that the impugned regulations accord with 217 of the Constitution. That then brings us to the second issue, which is whether or not the minister had the requisite authority to draft the regulations. As my colleague has already identified, the minister's case failed on that point, where the court said Section 2.1 of the Framework Act empowers organs of state to
We seem to have lost Mr. Mkhize. Mr. Mkhize, are you back?
I'm back.
Okay.
Yes. What was the last thing that you heard, Council?
Section 2.1, you were still at Section 2.1.
Section, yes. So the court was of the view that Section 2.1 provides organs of state with the requisite authority to craft their own procurement policies. Therefore, is neither necessary nor expedient for the minister to craft regulations which in turn seem to set parameters on how organs of state are going to procure. So this is very important to note, because then it speaks to the constitutionality of the actual text of the regulations, as opposed to the constitutionality of the person or the office that enacted the regulations. So in as much as the office that enacted the regulations is not recognized, it doesn't necessarily mean that the regulations themselves should be thrown to the wastebasket. So that's issue number one. Issue number two is that in dismissing the minister's appeal, the majority did not directly address the issue of the suspension of the period of invalidity that form parts of the SCA's order. As a matter of fact, this academic opinion is of the view that the court didn't interfere at all with the SCA's appeal order. And then some academics argue that this form means that as a consequence of the dismissal of the appeal, the order of the SCA was no longer suspended in terms of Section 1 of the Superior Courts Act, which would then mean that the period of suspension continued to run when the matter was introduced to the Court as an appeal up until judgment was granted. So it means that the period of suspension was never halted. So then that would mean that when the judgment was granted, because the period of suspension was never halted, it would present the issue that when the judgment is granted, then the regulations are then invalid immediately at the time, because at that stage, the period of suspension would then have run its course. But Section 18(1) of the Superior Courts Act provides that subsections 2 and 3, or in terms of sections 2 and 3 of the Act, and unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or an appeal is suspended pending the decision of an application for appeal. So in the regular running of Section 18(1) of the Superior Courts Act, in an appeal in the Constitutional Court, it would mean that operation of the order from the Supreme Court of Appeal, which is being challenged now in the Constitutional Court, that order be suspended as well as its execution. Now, in respect of this matter, the suspension would then include halting the operation of the period of invalidity. So it would mean that when the matter went to the Con Court at that point in time, whatever time had elapsed when the SCA judgment was granted up until the Con Court matter was in court, that the period of invalidity would stop. So if only 6 months had passed, it would mean that the suspension of period of invalidity would halt. Then you wait until the court judgment is completed, and then only then would the period of invalidity continue, or the suspension continue. And then that would mean then, by calculation of time, then that the 2017 regulations would only then become ineffective in February 2023 next year. This issue caused much confusion, leading to Treasury making a request to the Constitutional Court to provide direction as to what's meant to happen regarding the suspension of the period of invalidity, whether the regulations were immediately invalid as of 16 February 2022, or whether they'd only become invalid later on in February 2023. Now, in the adding on what I was dealing with earlier, in paragraph 120 of the judgment, the majority provides that the Procurement Act has made provision for the creation of a system of preference, and that that reality persists as long as Section 217, Section 2.1 is there. Now, the practical implication of this, I'm now going back to issue 1 of the notable issues, is that each organ of state is authorized to promulgate their own procurement policy. This is further reiterated by Treasury in their Treasury notes dealing with the issue when they were speaking to organs of state, where the Treasury reiterates that each organ of state must craft their own procurement policy. Now, according to us, this therefore means that for each organ of state, the following 3 issues are of immediate concern and should be dealt with immediately. Number 1 is that each organ of state must commence drafting their own procurement policy. This would be according with Section 2.1 of the Framework Act. It would also be according with 217 of the Constitution. It would also be according with the judgment in the Con Court, and Treasury has also indicated as such. Number 2, then each organ of state then has the imperative of putting into place a temporary mechanism to govern procurement, pending feedback from the Constitutional Court on the suspension of the period of invalidity and the promulgation of the 22 regulations. Because while this is still an issue, it doesn't mean that organs of state can't continue functioning, because if they cease functioning or cease procuring, this might have a negative effect on service delivery. Item number 3 is what I've just spoken of now, is that each organization has an imperative now of ensuring that service delivery is not disturbed by these changes. And in summary, that is the purpose of our presentation, to highlight these three considerations that each organ of state needs to deal with as of, we believe, the 16th of February 2022. That is then the end of our presentation, and we can take questions going forward.
Thank you so much to Mr. Mkhize and Mr. Mhlongo for such an informed or informative presentation. Colleagues and all attendees, this is now the chance to ask your questions or make comments. Mr. Mkhize and Mr. Mhlongo are still available to answer your questions. Trying to find questions. The only question that has been sent through at this point is clarity on the way forward, as to how then are the state organs supposed to comply, what is required of them in terms of compliance with the current legislative situation that we are now faced with. I did note that as part of the way forward, the presenters suggested, in fact, not suggested, only highlighted that the organs of state are now obliged to prepare their own preferential procurement policies, as confirmed by the majority judgment of the Concord. The question here is, what exactly in point form should be covered in those policies, in your view, gentlemen?
Okay. What we believe should be covered in the procurement policy, let's start with the founding document that establishes how procurement is meant to be conducted, which is Section 217 of the Constitution. So the pertinent issues that need to be covered in that respect is that the policy must speak to a procurement framework in line with the Section 27 of the Constitution, and also Section 2.1 of the Framework Act. So to ensure that it must do so in a manner that is fair, equitable, transparent, competitive, and cost effective. That's the first consideration. Second one is that in terms of 2172, each organ of state is authorized to then create a dispensation where they create within that policy categories of preference when allocating contracts, whether that's based on price or whatever objective criteria is established. Number three, it's then including in the procurement policy mechanisms that then protect and advance persons or category of persons disadvantaged by unfair discrimination. Now, as to whether or not they can be done specifically like the previous regulations had attempted to do by inserting pre-qualification criteria, is then based on whether or not we are accepting that, according to paragraph 116 of the Constitution, the content of the regulations themselves was fine. If we accept that would mean that an organ of state could then utilize those regulations as a basis for crafting their own policies.
Sorry, just to add also to my colleague's answer, which is predominantly the legal requirements for doing so and the legalities around providing regulations. But just a sentiment shared by the High Court was that these regulations should also be viewed or viewed as a tool to address localized and specific area-specific issues that Section 217 of the Constitution aims to redress. So then that would mean that what needs to be put in those regulations would be governed by the objectives of each state-owned enterprise, whether it be a local municipality, whether it be an institution, for example, like MKI. I hope that answers the question.
Answered. On my side, I'm not sure if everyone else understands. Are there any questions? Okay, it seems that your presentations were very clear and easy to understand, and we give you a round of applause. Okay, there's a hand. Mr. Mkiza, you wanna come in?
Yes, Council. I want to address Dr. Thandeka Ellison's question, which shows up in the chat, regarding what's transpired and Eskom's move. Now, the move made by Eskom is pursuant to one of the directives or notices issued by Treasury, where Treasury made it or gave an option that organs of state could then choose, if they so require, to be exempt from utilizing the Framework Act necessarily in order to craft or to procure this, pending the clarity from the Constitutional Court on whether or not the period of whether or not the suspension of the period of invalidity ended on 16 February 2022, because if it ended then, it would mean that the regulations are not effective from 16 February 2022 going forward, or alternatively, whether or not the regulations or the period of suspension ends in February 2023, which would then mean that between now and 2023, you can still use the regulations. So Treasury is still waiting for that answer from the Constitutional Court. Also, what Treasury has done, which I failed to mention, is that they have drafted 2022 regulations, which they were out for comment, and I think the date for written submission are closed on 11 April 2022. Now, obviously, that has those regulations to go through the process of public participation and then back and forth with Parliament, and thereafter be promulgated. But now, up until when they are actually in effect, whether it's the Concord coming back to Treasury, or whether it's when the 22 regulations come of effect, between now and then, each organ of state can choose to take Eskom's option. But the problem with Eskom's option is that it has the potential of disregarding Section 217 2 of the Constitution, in that if the focus is on price, it then cuts out or it makes competing for entities like us virtually impossible, because bigger entities will always outbid what you call the smaller entities. They will always outprice smaller entities. They will always come through with more experience, not necessarily better expertise, and it therefore would mean that smaller entities, which are usually come from previously disadvantaged backgrounds or previously affected by unfair discrimination, would then be left out. So in summation, the suggestion for a way forward is a temporary mechanism to deal with procurement that aligns with Section 217 of the Constitution, but at the same time, what you call it, respects 2171 for a period pending the results from the court, and at the same time embarking on the longer project of putting together a procurement policy, which, when it comes to effect, be it 6 months, 7 months from now on, that organ of state can rely on their own procurement policy.
Which also complies with 217 of the Constitution, I suppose. Thank you so much for that response. And Dr. Ellenson is also expressing her gratitude on the clarification and advice. And she is commending the presenters for presenting very well. Thank you so much. And for those who are not aware, Dr. Thandeka Ellenson is the CEO of the Moses Kotane Institute, who has made this workshop possible by allowing the two practicing attorneys, Kize and Mhlongo, to come in and present for the benefit not only of the Moses Kotane Institute, but of the provincial government of KZN and national attendees, if there are any. Our virtual meetings as the Moses Kotane Institute are always open to all people who are able to attend. Thank you very much. I don't see any other comments on the chat, nor do I have any on my side. I think it was a very well presentation, very well. There's I see hands from Ms. Lamini. Thank you so much, gentlemen. Thank you so much, MKI colleagues, and thank you so much to all our external attendees. May you enjoy your long weekend. Thank you.
Thank you for the opportunity. Cheers.
Thank you very much for the opportunity. Bye.
Thank you. Bye.
Oh, khona usakhona uStha. Yes, Sir, I don't have meeting. Okay.